very much for joining this webinar, and I hope you're all staying safe in this COVID-19 crisis that we're having. I've been asked to talk about developing best practice for agricultural data management, and this will be coming from an Australian perspective and out of a couple of research projects that we have been involved in over the last 3 to 4 years in Australia, looking at how best to adopt digital technologies within our agricultural industries, but also how to ensure that our farmers are protected and are able to feel safe in sharing their agricultural data with some of the technology providers and some of the third parties who are interested in their agricultural data, for example. So I've given you my email there. I'm more than happy to answer any questions, or you feel free to email me following up if you would like any further information as well. But as I said, I work with Griffith University in Brisbane in the law school, but also I'm involved in a research centre known as the Australian Centre for Intellectual Property in Agriculture, and we have focused for over 20 years on the IP issues as they relate to agriculture. So just to give some background on the principles where our best practice principles have come from. And some of you may be familiar with this particular project, but this was a project that was funded by the Australian government, the Department of Agriculture and Water, in 2015 and 2016. We have 15 rural development corporations in Australia that receive all of the research funding for those industries. So you can see at the bottom of that slide, we have fisheries, we have dairy, we have cotton, we have wool, meat processing, eggs, pork, grains, horticulture, wine, sugar, meat and livestock, etc. So all 15 of our rural development corporations, or RDCs, recognised that they needed to focus and address on issues relating to digital technology adoption in agriculture. And one aspect of that was the collection and aggregation and sharing of the agricultural data. And as part of that larger project, and I've given you the link there so you can have a look at, there were 6 reports that were done looking at a whole range of issues. But this particular technical report focused on the legal dimensions of digital agriculture as we were encountering them in Australia at that particular time, focusing particularly on issues around concerns around who owned agricultural data, who could access that data, concerns around privacy, and essentially the lack of trust that our farmers had in the way that their agricultural data was being accessed and managed. So that report again is available for you to have a look at. Apologies for the typographical error in the title, but it is Legal Dimensions of Digital Agriculture in the link. That will take you to there. There were many recommendations from these research reports, and one was that how best to move Australian industry forward with inspiring farmers with confidence in the way that their agricultural data could be used for the benefit of industries as a whole, benefit of government, but also benefit of broader community interest in what was happening in Australian agriculture. Following these reports, we saw a huge shift in privacy law around the world, and essentially emanating out of Europe, but the ramifications have been felt all around the world, and in different countries around the world there have been mirror pieces of legislation that have adopted these key principles. But just to focus on the big shift in privacy law and what this means for agricultural data and the way that agricultural data is managed and shared. The GDPR, the General Data Protection Regulation, came into operation in May 2018. And this really was a significant shift because we saw for the first time the focus was on responsibility that needed to be taken by by data managers as to how they dealt with personal data. So while the GDPR focuses on personal data, many of the companies and multinationals that were collecting data around agricultural data also, by virtue of the nature of agricultural data, often collect personal data around the farmer, whether it be financial data or health data that's often given to access finance or loans from insurance companies or from finance companies, for example. So what we saw with the GDPR was essentially the key changes across the world that have been felt, and basically companies have been revising their privacy policies and their data management policies in light of this, is the notion of an informed purpose-specific consent. So individuals would have to give consent for a particular purpose, but if a secondary or a third use is desired, then the requirement under GDPR is that you come back to the original data contributor and you ask for additional consents. The right of portability is another important right that we saw in the GDPR because of the ability or the need for individuals to take their data from one service provider to another service provider without any loss of information or data. And there's also the right to be forgotten. In addition, in the following year, we saw the regulation of the free flow of non-personal data, and why this is particularly of interest to managers of agricultural data is that it actually makes explicit reference within that regulation that machine-generated ag data is categorized as non-personal data. So it's quite interesting that when we talk about agricultural data, we realize that there are many, many different types of data that we're talking about, whether it be soil, input data, chemical, productivity data, yield data, climate, environment, a whole raft of data. But some of that, as I said, may in fact under privacy law be tied up with personal data of the farmer themselves. And that is where agricultural data sits in a very unique position. Obviously, all personal data of the farmer is not agricultural data, but certainly some ag data of the farmer may contain personal data. So there is that conflation, which makes it a little bit more complicated. What's interesting is to categorize under the regulation that you have machine-generated data is non-personal. The issue now, when you have machinery and tractors and sensors located on individuals' farms, and that data can be GPS located down to a specific spot on a specific farm, there is argument or concern that that can readily identify an individual. So some machine-generated data, when it's GPS located machinery, then it's arguably, it could potentially be personal data, but the regulation makes clear that that's not how it's going to be treated essentially in Europe. So what we saw essentially is this concern from farmers and from agricultural industries was that what is ag data? We hear a lot around agricultural data or farm data, and there is no clear legal resolution of this issue of whether agricultural data can be categorized clearly as personal data or farm data. We know that it's a combination of both, and some instances it's one, on some instances it's of the other. I thought it might be interesting that The Australian Government Productivity Commission actually had an inquiry into data availability and use. And what they highlighted, and I think it's useful to talk about this here, is the way people think about rights to privacy in relation to data. And that is that a common misapprehension or misperception is that privacy laws, whether it be GDPR or laws in other countries that regulate personal information, or the privacy policies of individual organisations give individuals ownership over data created by or about them. Unfortunately, as we know, privacy legislation, which is really the tool that most countries use to protect individuals or give individuals some control over data, regulates how their personal information is collected, used and disclosed, not so much information that is generated about them. So this is kind of the issue when we're talking about agricultural data and how farmers feel about their data. In the earlier report, this Legal Dimensions of Digital Agriculture, we did a detailed survey, which is available as well, of 1,000 farmers in Australia across all industries from all different regions within Australia about their attitudes to data sharing. And a lot of their concerns were around the fact that they were not aware, of who had their data in the first place, particularly we're dealing with international data aggregators, but also who those data aggregators were sharing their ag data with. So the third-party service providers, often we saw an on-sharing without any knowledge of the farmer themselves. So there was quite a high level of mistrust around some of the data aggregators because they were not, farmers were not aware of their data management practices. So essentially, this whole issue of what agricultural data is personal data is not clear, and every policy that I've looked at of agricultural technology providers, it's not very clear either from the corporation's perspectives as to how they're treating agricultural data. So in many cases, the companies will have a privacy policy, and that privacy policy will deal with personal data, and it will comply with the GDPR or a number of other privacy laws, depending on which country you're based in. So what we don't see is data management policies that focus specifically on agricultural data. And this is the other data that may not be personal data. So we're talking animal health, soil, climate, agronomic data, or, you know, biosecurity data, for example. So there is this kind of mismatch in a lot of the agricultural technology providers' contracts around, they refer to their privacy policies, but we know that their privacy policies by and large deal with personal data. But we're not seeing a mirror image within their data management practices around how agricultural data of the farmer will be managed. And so this was something that we tried to address in Australia by a second research project. As I said, many companies brought themselves into line with the GDPR, introducing consent provisions. But as I said, this really is only relevant for personal data. So when we were looking at how should agricultural data be managed, we had a secondary kind of research project, and we worked with a handful, 10 out of our 15 industries, to develop some principles that would give guidance to the industries themselves, but also that could be used by the farmers to feel confident that the people that they were engaging with provision of services and digital technologies had some awareness of those areas around concern that they had. So essentially, and you can see that growing a digital future in agriculture, which, as I said, is Australian focused. But these principles that we developed in terms of best practice, I'll see if I can take you to the web page, if that, okay, it's not going to work. Sorry, if you can take that, you can go there yourself. Essentially what we've done is set up a raft of kind of high level terms, areas of contention that we identified through the research where farmers were concerned that agricultural data aggregators were not addressing in any of their policies or their license agreements. So in terms of what we addressed was essentially trying to ensure that the terms of any data management policies were transparent to farmers. And this means that they weren't hidden on a website, that due notice of these terms were given to farmers at the point of sale, of delivery of the device or the technology. If there were provisions around consent, it had to be made clear that it was a one-off purpose-specific consent and that no secondary uses would be able to be made unless the technology provider came back to the original contributor and sought permission in those instances. The other fundamental important area that our farmers were concerned about was where their data was going and who it was being shared with. They wanted the ability to move their data, so a right of portability, to move their data from one service provider to another without any penalty or without loss of data. We heard a lot of stories of when trying to shift data from one company to another company, that they could only get 3 years of data or 12 months of data. And in some cases it wasn't, it was hard copy data, it wasn't even in a digital form. So there were limitations on their ability to move data in and out of different companies. So once you began with one company, you were essentially locked in, which raises significant competition issues. Other farmers were also kind of aware of the fact that in some cases they were unable to remove their data from certain systems once they ceased a certain service provision. So all of these issues, if they are dealt with at the commencement of a relationship, a commercial relationship, can be addressed, and the parties are in a situation where they understand how that business relationship is going to go forward. Most of the time, from the survey and the information that we were receiving from our farmers within our industries, that they had no knowledge of any of these provisions, whether they could move their data, could they exit agreements, and was their data being shared with third parties without their knowledge, for example. So these were all the matters that we addressed in our best practice principles for Australian agricultural data managers. What we're really conscious of is the fact that we understand that there is a global push for open access to agricultural data, and that many of the philanthropic funders require open access to ag data, and governments are similarly taking that same approach. What we're trying to work with industry is to recognise, before you can open data and make it available for the industry or for a broader community, you have to understand what data you have in terms of what data is able to be shared and what data is not able to be shared. And it comes back to that divide between what is personal data and what is agricultural data. So it's not inconsistent to open ag data and to respect privacy and personal information at the same time, essentially. So they're not incompatible, but it's being in a position as a data aggregator that we're trying to educate technology providers that they do need to manage data in a way that they can identify what is able to be shared and what is not able to be shared, essentially. So I'm sorry I haven't been able to share the actual principles themselves, but you can access those yourselves. But essentially that is what we have tried to do with our industry now. And part of that, and we've seen it in Europe and the US as well, is there are farm data codes of practice that basically embody those broad principles around portability, around security and privacy of personal information, and issues around consent. We recently in Australia here in February have a draft farm data code that attempts to provide guidance to industry and to farmers about what best practice looks like in terms of agricultural data management. That's open for consultation at the moment. So there's a 6-month window where our National Farmers Federation is seeking feedback on that, because obviously with every ag data code, none of them are perfect and there's always room for improvement. So what's really important, as we've recognised, is the need for feedback on how the code is working and ability to improve the code through working on that feedback and recognising what industry needs. So how best to open up ag data is basically essentially having a data management system where you have privacy by design. You work from the bottom up in terms of you recognise what is personal information. You essentially, we're seeing more and more that there are specific individuals who have the role as a data protection officer, who will be able to make the decisions around when and what to share in terms of what agricultural data can be shared. The general GDPR message is you don't have or take more data than what you need, and don't use the data for purposes but beyond what is agreed, and the ability for people to actually exit out of some of the technology agreements should they so wish. So that's essentially a bit of a whirlwind tour of, the way in which we've developed our principles. I think I'm more than happy to take questions, given that I wasn't able to share them with you. So I'll stop sharing.
Okay, thank you very much, Leanne. If anyone has any questions, I will give you the ability to use your microphone so you can ask your question. No questions? You can also chat your questions if you don't want to ask out loud. Yes, go ahead.
And I'm happy to supply the slides as well.
Okay, that would be great. Oh, we have a raised hand. So you should now have the ability to unmute yourself if you'd like to ask your question out loud.
Erica, just in relation to your question, did the paper discuss data sharing across jurisdictions of different countries? No, it is Australian focused, but we recognise that at the end of the day, when you're talking around data sharing, even when you're dealing with multinational organisations, there will always be what we call a choice of law clause from that corporation or from that business, where they choose a particular jurisdiction which will govern their contract. So many of the data licenses, they actually have a home jurisdiction. So even though data sharing happens across countries, when you're dealing with a particular technology provider, that data will be managed by one country's laws, essentially. Sorry. Can I talk about privacy and other contexts other than Australia? Certainly, you know, privacy laws around the world pretty much take a similar approach, and that is that general divide between privacy law generally only protects personal information. And the way personal information has been decided in many jurisdictions is it's information that will help you identify an individual. The problem that we have with agricultural data is the fact that on scale, when you're talking climate, environmental data, soil data from satellites, you know, arguably that's not personal. But when you bring that down through a GPS located sensor and it's in the soil of a particular farmer's plot of land on a particular space, and all of that information is drawn down onto that farm, and at that point, then legally the issue becomes, will that data basically, could that data be tied back to that particular farmer? And that's the complexity of agricultural data and trying to isolate it from privacy law and personal data. How much does incorporation of a data protection officer instill trust? I think many of the farmers feel as though if they have a point of contact within an organisation that they can talk through their concerns about data management, that certainly is something that builds trust in farmers, that they can have someone to ask questions and someone who's familiar with the way in which that particular business or company deals with their agricultural data. Yeah, the FAIR principles, so findable, accessible, interoperable and reusable. Yes, had a long association with the FAIR principles. I think in an earlier seminar, some of us talked about FAIR and FLAIR. When we talk about findable and accessible, the legal accessibility and rights to access data comes under that kind of broad umbrella. So we're talking about, can you access the data? You can only access data that's legally able to be accessed. And that is where I would argue that all these principles around privacy law sit within the FAIR principles, is that it's not only a technological access issue, but it needs to be thought of as a legal access issue as well, because not all data can be shared. Are we collaborating with other countries on digital agriculture? Well, certainly the work that we've been doing on the legal dimensions, I've been working with the OECD on some of these data principles as well, and other international organisations as well. So there is some, what do you say, affiliations around some of these issues that we've been looking at. Do you know if data collected through smartphone surveys would be considered as machine generated? Well, I don't have a legal, what do you say, a legal decision of a court, but certainly that from my understanding of the way the data regulation works, the free flow directive, I think smartphone would just be treated like any other machine generated data, as in it's not non-personal data. Obviously I have a problem with that, because obviously if you're collecting personal information about a farmer through any machine, the fact that it's collected through a machine doesn't make it non-personal. So, is it possible to provide international valid licenses to ag data? Most companies that are aggregating ag data will have a license, and often they are tailor-made to particular jurisdictions. I know, for example, if we use John Deere as an example, they have a North American license. They have, that license is tailor-made for an Australian jurisdiction as well. So you'll often see, or Australia, New Zealand, you'll often see international companies might try to use one contract across all countries, but they recognise that in certain countries they'll have to make changes because of the laws of that particular country. Which sectors have the most open data actors and how are they empowered? In terms of open data, many industries are really success stories for opening data. Every industry still has this issue around privacy laws. So whether it's mining, health, agriculture, whatever sector you're looking at, privacy law basically will require that privacy law of the country needs to be respected. Farmers are certainly differentiated according to size and level of commercialisation. Certainly what we're seeing is really in Australia, the small farmers or smaller farmers tend to have a closer relationship with some of their advisors, some of their agronomists who are data collectors as well. So we're not just talking about large technology providers, but we're also encountering issues with advisors and agronomists who've been helping farmers for many generations, who now find themselves with large collections of agricultural data, which they find themselves, with a big collection of farmers' data that they're being approached by bigger companies to sell. So there have been examples where advisors or agronomists who've worked with farmers for generations have retired and they've sold their business to a big company, and the farmers haven't been happy that their data has ended up in the hands of a large multinational or a large national organisation when they only ever really contracted with an individual in their location. So advisors and agronomists as well is another area, because they are basically data aggregators as well. What are some of the best examples that demonstrate the benefit of farmers making their data available to be linked to other data for better decision making? Look, there's many examples of in terms of improved nitrogen use, improved yield predictions, improved quality of cropping, etc. There's many at a small cooperative level. there's many industry examples. How well they're documented, I know anecdotally there's lots of good examples, but I haven't really seen many, what do you say, successful stories published or made available in that way. But I'm sure, Helen, certainly within the Australian industry, each of the RDCs would certainly have, you know, success stories of where data sharing has helped the industry and the farmers themselves as well. Sorry if I've missed some questions, I think.
No, I think that's okay. Oh, there's one more.
What are some of the methods used to incentivize farmers' provision of data? We've seen discount on services, for example, provision of services, provision of advice. So, and the sharing of benchmarking data, for example. So some farmers who give their data into a cooperative model or who share it with other farmers will get the benefit of a benchmarking report, so they can see where improvements have been made by other people and they can learn from that. You know, there's lots of methods used to incentivize, but what we have seen is that farmers that they basically just want to be told exactly how their data is going to be used, and then they will feel more confident in entering data sharing arrangements, and they can make a judgment as to what is a proper incentive for sharing. Sorry, did access to private data once relate to skepticism linked to technological access? Yeah, look, certainly the technological accessibility issue is a really significant one when you're looking at data, but I think what has been forgotten in the kind of focus on the technological access is this legal access about whether you can or you should be able to access certain data. The fact that some people had difficulty accessing the data is one thing. It's a question of how that data is being stored and managed at the other end, and whether the data is in a form. What we're seeing is with the GDPR in Australia, we're seeing it too, is things like a consumer data right we're talking about in Australia, where, you know, for a data manager to be able to give data back to an individual, they have to know what data they had to start with and what data essentially is personal data. So it makes it a very complex responsibility to hold data. And that's a big shift, because in the past there was this general kind of sponge that everyone was grabbing as much ag data as they can, because there was no no responsibility for the way in which it's managed. And I think the last couple of years has highlighted how important it is that the data, people who are holding data have to hold it in a responsible way and manage it appropriately. P2D, identify the critical need for data education, literacy and skills development. Yeah, that's still an ongoing conversation, Helen. You know, it's all about probably funding for those kind of workshops and training. The farm data code is one step in that direction. Certainly, I think, you know, in terms of priorities at the moment, particularly in 2020, and with the drought and the floods and everything else that we've had, there's really been probably a bit of a refocusing that's happened. How different expertise of agriculture, like agronomy, horticulture, entomology, pathology, are linked for data with farmers and other stakeholders? That's a very good question. It really depends. It really depends on how all of those different types of data are being held and who's holding them and what affiliations are brought together. If you're talking about government, there can be a conglomeration of expertise in that way, but often we're seeing animal data being kept by one company and input data being kept by another company. So there really isn't that wholesale kind of collaboration or exchange.
Okay, thank you. Oh, there's one more. We'll make this the
Okay, Robert Reed, in Australia, our
last
farmers,
question for you, Leanne.
sure. Our farmers given a guided tour of the data collection deposit aggregation system, or is there no transparency? Will this help with? Look, to be honest, at present, the Farm Data Code is our attempt to try and get companies to be more forthcoming with what their terms are. Currently, I would say farmers aren't being given a guided tour of what data management practices are with their advisors or their economists or their tech providers, essentially. Creative Commons licenses are fantastic, you know, great for sharing of ag data. Same thing, it's great. But a lot, you know, it's that whole issue around, can you creatively granted Creative Commons license over ag data that also contains personal data. This is the kind of the challenge.